Swayam Prabha. Digital India. Educated India.
Moving further to Article 16, which is also part of the doctrine of equality under the Constitution of India. Article 16 declares that no individual shall be disqualified for or prejudiced against in any government occupation or position solely based on religious belief, ethnicity, class, gender, ancestry, birthplace, residency, or any combination of these factors. It also authorizes Parliament to enact legislations requiring residence in that union territory or state before appointment or employment in that union territory or state. So, while domicile or residency may be required for employment in a particular union territory or state, no government can actually discriminate in public employment, which means the rule is equal opportunity in public employment is to be given by the Constitution, is to be protected by the Constitution. Now, can reservation for jobs and position for the backward sections here be made a norm? Right? There are 4 exceptions to the rule of equality in public employment, and they are that the Parliament, one, can prescribe residency as a rule or as a condition for employment of appointment, and as per the Public Employment Requirement as to Residence Act of 1957, there was till this law was prevalent in 1974. In certain states, this residence requirement can be brought about. Second, the state can provide for reservation for backward classes who are not adequately represented in the state services. So, reservation in public employment is an exception to the rule under Article 16. Third, a law can provide that the incumbent of any office related to religious or denominations, institutions, or members of governing body should belong to a particular religion or to a denomination, which means it's not open employment, especially in religious and other denominations. It can be given to those members who are, in terms of a particular caste, family, and so on and so forth. So these are some things that are applicable to public temples. The state is permitted to make reservation up to 10% of its appointment in favor of economically weaker sections of the community, and that is how probably certain exceptions come into place under Article 16. Now, Article 16 has its own set of controversy, especially with the Mandal Commission report in 1992, where in 1979 Morarji Desai government appointed the second backward classes commission under the chairmanship of Shri B.P. Mandal. And in terms of the Articles 340 of the Constitution, to investigate the conditions of socially and educationally backward sections of the community and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3,743 castes as socially and educationally backward in the country. They constituted nearly 52% of the population, but this is 52% excluding SC and STs, that is scheduled caste and scheduled tribes. The Commission recommended a reservation of 27% in government jobs for these other backward classes, so that a total reservation of all SC, ST, and OBC amounts to around 50% of government employment. It was after nearly 10 years in 1990 that Shri VP Singh government declared reservation of 27% for OBCs. And in 1991, the Narasimha Rao government introduced 2 changes. One, they said preference to poorer sections among the OBCs in the 27%. This is the economic criteria adoption that was brought in. And reservation of another 10% of jobs for other economically backward sections of the community who are not covered by the existing scheme of reservation. This resulted in the most famous case called the Mandal case of 1992, wherein the scope and extent of Article 16, subclass 4, which provides for reservation of jobs for backward classes, was examined thoroughly by the Supreme Court of India. The court rejected the additional 10% reservation for other economically backward sections of the community, but constitutionally upheld the 27% reservation for OBCs with certain conditions or riders as the case may be. However, it resulted in a lot of protest called the Mandal Commission protest because a lot of people felt that they were left out from the category of 3,743 socially and educationally backward sections of the community. Uh, so that I think was what was the background to Article 14, 15, and 16. However, I think while we talk about Article 14, 15, and 16, it would be pertinent at this point of time to understand and know that Article 13 of the Constitution very clearly states that uh, there cannot be any law that is inconsistent with or in derogation of fundamental rights. And equality is a fundamental right. So there cannot be a law in derogation of the same. And hence, many attempts to understanding Article 14, 15, and 16 in terms of the rule of equality has been made through our constitutional history. For example, how do we look at Article 14 in terms of the non-arbitrary rule? Non-arbitrary rule very clearly means that administrative orders have to be reasoned orders. If they are not reasoned, they may amount to be arbitrary in nature and character. So reasons must be stated why a particular decision is taken by a bureaucrat or an officer in the government. And of course, when the reasons are substantial in character, it amounts to good governance. So public administration is bound by the rule of equality, the rule of non-discrimination, and reasons for order are very, very important. If those reasons are absent, it would amount to violation of Article 14. Of course, let's take certain instances or examples of equality principle that has to be applied and followed by all government agencies. Let's assume that there is a government university or a college. Now, can it practice arbitrary admission process or process that is not fair or transparent? I think the educational department would be duty bound to follow an objective criteria for admission wherever the demand is more than the number of seats that are available. So admissions to even government aided institutions or government supported institutions have to follow a transparent, non-arbitrary, fair manner of admission process. So this is a non-compromisable condition that is laid down by the rule of equality, and hence you will notice on several issues during the process of admission, there have been several court cases and challenges that have been taken from time to time. As we all know, that while we have spoken about reservation in educational employment or educational institution is also provided for under the constitution, and hence the kind of admission through reservation has been challenged on many occasions as being violative of the constitution. Of course, where does arbitrariness come in? Suppose the government is awarding contracts or what we call as government, procurement. And while they award this contract, they are actually not doing it in a fair, transparent manner, and it results in favoritism or nepotism, as the case may be. And the rule of tendering or fair procedure of procurement is not followed, it would be challenged as being arbitrary exercise of power, and hence to strike down that kind of executive administrative action, the challenge would be under Article 14, saying that the rule of equality, the rule of equal opportunity in public procurement has not been followed. So, anything in terms of regulating public administration, in limiting the power of public administration, in limiting the exercise of arbitrariness, I think Article 14 has been the constitutional challenge that has been taken from time to time. Yet another example could be allotment of government lands. Sometimes, government does make these allotments, say, you have a developmental authority that acquires land and then divides the land among the citizens, especially in urban areas, or it could be in industrial areas as well. Now, whenever the government does allotment of land, it is the instrumentality of the state through, say, any kind of authority or a body or an institution that is representing the government, and the government ought to represent the will of all sections of the community and not just one section of the community. So anything that is done, uh, to favor a particular caste, a community, a religion, or anyone from a very sensitive political consideration or a background, will result in exercise of arbitrary power. Now, these are instances where politicians or political parties or government of the day would want to do what we call as the vote bank kind of politics or schemes for furthering their own cause. So, to check such kind of arbitrariness, where only one party is favored and the other has been annoyed and disadvantaged because of that kind of a governmental action, I think the rule on equality becomes the intervening factor for the courts to come. One thing that we have to understand is that there is always power in government. It's huge power. With every power comes responsibility, no doubt about that. However, there is a very famous quote which says that power corrupts and absolute power corrupts absolutely. And hence, while there is power, there is obviously some kind of discretion in public administration. And that discretion sometimes gets to be abused because we are human beings and we have the tendency of being pulled and pushed towards different sides because of so many considerations. The considerations could be family, it could be society, it could be caste, it could be religion, it could be personal to a larger extent, or it could be something that is empowered through some kind of a force or authority of some superior bodies. So, to check those pulls and actions, I think the rule of equality has played a very, very important factor. For example, is there a tendency of public administration to be biased? Of course, the rule of bias is a rule of public administration. It's a rule of public policy in which you are not supposed to exercise it. Now, biases can be of several kinds. It can be personal bias towards individuals. It can be subject matter bias because you think you are involved in that town, city, or village, and then you tend to have your biases. And to be honest, when there is some kind of bias, of course, it will result in maladministration. It will result in infringement of the rule of equality. And there are clear evidences in our constitutional history of the biases that have been applied from time to time. So, Article 14 does, to a larger extent, in terms of good governance, bring in what we call as the principles of natural justice. That has to be followed in public administration. So, you have to be very objective. You have to follow the natural justice principle in your administrative action, ensuring good governance. And anything that you do in contravention of the principles of natural justice would be alleged to be in a malified manner, not bona fide. Bona fide means in a good faith, and malified means in bad faith. And hence, the rule of equality very closely touches what we call as the doctrine of fairness and the doctrine of good faith. So you should not only act fairly, you must actually behave in a manner that ought to be fair. So it is not fairness in terms of just the substantive nature of the order. You must also procedurally be fair. So fairness has two components: the actual fairness and the procedural fairness. And hence, good faith is a principle that applies to all activities of good governmental action. And I think that's the rule that has to be applied from time to time. Why should the rule of equality have the rule of fairness and good faith? For the simple reason is that very often than not, you will notice that certain classes of citizens and communities in society tend to have special treatment sometimes. Caste politics in India is a reality, and you recognize the caste to be so strong that the leaders and the politicians of the same caste have a tendency to actually favor their own class of individuals, because finally they are looking at being voted again into power, and hence special treatment to certain castes who have occupied the seat of power has always been the tendency of policymakers sometimes, and this has been more aligned to legislative actions, which have extended to executive actions as well. So I think the court has been a very good observant of these kinds of misuse and abuse of power, and trying to grant special status and privilege and immunities to certain kinds of individuals in the society. And that is where I think the limit has been something that has been checked by the application of Article 14 in the Constitution. There have been so many instances of arbitrary actions in the government that have been taken to the court. And you will notice that suppose you are applying for passport and you have been denied that passport without any reason, not based on any kind of rule book. Rule of law is not followed, but it is the biases of the officer that has been applied in denying you a passport. Can you challenge the same in the court of law as being violative of Article 14? The answer is absolutely yes. Similarly, I think there have been a lot of wrong actions sometimes which have been taken by so many agencies in the government, where the application of the principles of fairness, good faith, and equality have not been applied. Can all of these then result in some kind of an action as to the violation of fundamental rights? The answer should be, of course, found in Article 14. Now, let us look at privileges of resources as being granted by the government. Now, very often than not, because there is political pressure and political, compulsions, issues like water sometimes has been discriminated. The government actually allocates water only to certain sections in the community, certain villages, certain privileges, certain people who can afford it sometimes, or certain institutions who can actually afford it, and not give it equally to every individual, as the case may be. These uses of water, you would notice, is the basic essence of life, and any discrimination on the use of water simply cannot be bared under a democratic constitutional value or principle. So the underlying principle of Article 14 is that any governmental action must be clear in terms of what objective it tends to serve, and any discrimination that the government will attempt to enact or follow will be struck down as being arbitrary and violating Article 14. Going forward, you will notice that we have various governmental initiatives. This could be initiatives that require certain amount of certainty, certain amount of uniformity in its application. Take the example of, say, disinvestments, or take the example of allowing investments or allowing businesses. Again, you will notice that a lot of businesses in India may found governmental actions to be arbitrary, as favoring only one group of individuals and not favoring or giving equal opportunity to everyone. So when governments have applied the rule of bias towards businesses or businessmen, and trying to promote a certain category of individuals to make profits, I think those sections of the community have to be checked, and I think the government also has to check its action in applying the rule of fairness in promoting businesses as well. Uh, of course, the rule of equality is about equal pay for equal work, and this very clearly brings in gender justice to a larger extent. And gender justice is very, very critical and important component of equality. And it is not equality only in, say, educational institutions at the time of admission. It is equality in public employment at the time of joining service. It could be equality to be treated at the time of promotions as well. So, administrative actions that violate equality come under the scrutiny of the court, and any such actions that are based either on a statute or some kind of an administrative executive action, which is something that violates the principles of the constitution, are set aside by the courts, and the courts have a very clear rule of intervention wherever unequal treatment has been applied, where inequality is practiced, where the actions are wholly unjustified, unconstitutional, or are they tend to be arbitrary, and hence the so-called exclusionary exercise of administrative action are definitely not something that the courts are going to entertain. There are many such instances of uh, of intervention. There are many cases of intervention by the courts. This could be in terms of the issues of say granting aid to certain kinds of institutions, granting coal licenses and resource licenses. In terms of say interpretation of law, sometimes which tend to be one-sided or arbitrary. Uh, I think it is quite acceptable in as a democratic value, as a constitutional value, that citizens have a legitimate expectation from the government to act fair. This is a legitimate expectation. Naturally, if you are a person with authority, that with authority comes responsibility. With responsibility comes the duty to act fairly, the duty to act, in a non-arbitrary manner. So I think the doctrine of legitimate expectation is that any kind of governmental action is non-arbitrary, it is fair, and it's non-discriminatory as well. Now, why is the rule of equality so stressed upon, and why do we speak about it so much in terms of our constitutional values? One, you have to understand that India is quite a big nation. It's a big country with a lot of pressure of population, growth, employment, and government employment is often preferred by citizens as being secure and so on and so forth. It has its own privileges in government employment. Second, I think in terms of aspiration, I think there are different state governments and different kinds of activities that happen across the country. This is a vast economic and a social fabric that this country has. So, getting into government contracts, getting into government largesses, getting government to give you licenses is quite huge for people, and that is the trajectory of growth in many businesses as well. So, government is a mechanism for growth. Government is a catalyst for growth. Government is the growth sometimes itself, and hence, without the licenses, permissions, or without partnerships with the government, businesses cannot flourish. And hence, the government is not only giving you employment to citizens directly, but it is also giving businesses an opportunity to make profits, make market conditions quite suitable to the economy. And hence, it is widely common that disparity may be practiced. Disparity in terms of who to be employed, when to be employed, disparities in terms of which companies should be allocated what kind of resources. So there is a huge amount of unequalness in seeking government grants. Because approaching the government in India itself becomes a challenge. Who can actually approach and what it can be done? So, and there is a lot of quid pro quo, or the personal kind of a favor. I do one to you, you do one thing back to me. The rule of quid pro quo that happens, and this is one form of corruption. Of course, it is. It's not only a corruption is to be named in terms of money exchange. So subjectivity can also creep in at time to time, and hence, I think people's legitimate expectation for the government to act in a fair manner is, I think, very, very critical and important. And I think that is something that everyone looks up to in government. Finally, just to conclude on the broader aspects, you will notice that we as citizens have the right to claim equality, right? And the claim of equality is against illegality. So any practice of inequality is nothing but illegality. It violates the principles of the Constitution. It violates the directive principles of state policy, which the states are duty bound to follow. And equality is rooted as the foundation basic feature of the Constitution, for which any kind of compromise is definitely not permitted. Uh, this also stems from the fact that the government has the policy discretion to make from time to time. There are certain policy considerations. The government may be forced to make certain policy exemptions. For example, say tax exemptions, sometimes it has to be made for a certain section of the community, so on and so forth. So there are those kinds of parameters that can be justified, obviously, as the exceptions to equality, because again, we must accept that the rule of equality is not an absolute rule. Exceptions are apparently not only recognized in the constitution but also can be justified as reasonable exceptions or reasonable classifications, as the case may be. However, the term here reasonable then becomes very important. If there is a public policy justification for that kind of reasonable classification, then the courts may probably allow you to deviate from the absolute rule of equality whenever it is found necessary, and whenever it is found intelligible to do so in terms of our practices. So, intelligible differentia, this is the rule of law. Intelligible differentia can be practiced to make the distinction in terms of the classification, right? If you have an intelligible differential treatment to be given to a group of individuals, within that group you want to divide and classify them, then with proper public policy consideration, it can still be done so. So that also has been merited through various cases that have been pronounced by the court from time to time. Looking at Article 16 of the Constitution of India, one will understand that the rule of equality, which is basically laid down by Article 14, is extended to Article 16 of the Constitution as well. However, in Article 16, it is specifically of equality of opportunity in public employment. The term equal opportunity, in public employment is quite subjective in nature and can differ in terms of its interpretation. And one would notice that it is the duty of the state, while it tries to ensure equality, to remove any forms of discrimination that may exist, so as to create equal opportunity, not only to the backward sections of the community, but also to every person who may be seeking public employment. However, Article 16 has been referred to as this article that talks about affirmative action, which means that the state must owe and do positive obligation. They must use Article 16 to render social justice. They must provide for some kind of a quota, some kind of a benefit to a particular section which is considered backward or maybe a minority group. And through affirmative action in public employment, elevation of the backwardness and to protect the interest of minorities, Article 16 can be used by the state. And hence, Article 16 sometimes is also called as positive discrimination. But the word discrimination is definitely not definitely positive in any other sense. So you will notice that whenever Article 16 is used, it is used for some kind of an affirmative action in providing for some kind of reservation in public employment. Of course, the state in India is a great opportunity for public employment. So a lot of people look up to the state services for many reasons, because there is security of tenure, there is doctrine of pleasure under the Constitution of India. You can only be removed by the rule of law, and the state provides opportunities and employment in various sections of governance and public administration. But that's not all. I think Constitution and the provisions of Article 16 apply to even public sector undertakings, which are government companies and government corporations. So government post is usually some kind of a preferred position for many youth in the country. And I think it is the duty of the government to make suitable conditions of employment so as to achieve the purpose of the constitutional mandate. Now, public employment, friends, is not just public employment. We have to understand that it is also public service. This is often something that is lost in terms of the loyalty to the state. Public service actually means that you're not a government servant, but you're a public servant. And this means that, of course, when you are going to be taken by the state, you have to fulfill certain minimum educational qualifications required for that given post. Maybe certain kinds of post would require physical fitnesses. They may require mental stability or a certain sense of moral integrity that has to be stated and proved before you are inducted to public employment. And also, public employment may differ in terms of its terms and conditions. So it's not going to be uniform. Central public employment will be slightly on a different term and condition. State may differ from state to state. And also in terms of the period of employment. For example, in certain states, the superannuation is at 58. It has now been extended to 60. In certain states, it's been extended to 62. Whereas central government employees may have 65 and so on and so forth. For example, judges of the Supreme Court retire at 65, judges of the High Court retire at 62. So these are differential, employment terms that may exist in public employment. So you're not talking of equality of those terms and conditions, but you should get equal opportunity. And I think that is specifically what Article 16 speaks about. Interestingly, while this clause was applicable in judgments like the Indra Swani versus Union of India case, it's a Supreme Court judgment of 1993, it was confined only to initial appointments. And that's what the court said, that you cannot have reservation in the matters of promotion. However, you notice that today such kind of reservations have been extended, and that has become a matter of Article 16. And please note, Article 16 can be invoked for issues like salary, when we say equal pay for equal work, has been invoked for leave, provident fund, gratuity, and other purposes, which definitely look at the term equality in its larger context. There are many cases that have been decided under Article 16. However, you should notice that there is a positive obligation on the state that it cannot discriminate between two individuals or two classes of individuals on the basis of caste. Caste cannot or should be the sole criteria of public employment, religion, sex, birth, color, etc. And I think to a larger extent, the Constitution also provides for what we call as the compassionate employment. Remember, while the Constitution does not say so, the Constitution has been used to seek compassionate employment. And you will notice that if a person who is in public service or who is as a public servant dies during service, compassionate employment is generally provided to a member of the family. However, please note, whether compassionate employment can be claimed as a matter of right. The answer is no, it cannot be. And hence the rules and conditions of public employment will be extended to compassionate employment as well. I think coming to the different cases or different case studies in which this has been done, most cases of government employment have been taken as challenged under Article 16, including issues of voluntary retirement schemes that have been promoted by certain entities of the government from time to time. So, voluntary retirement scheme is quite an interesting thing that happened in the 1990s, where to reduce the number of people and the final pay burden of the state, a lot of people were given this offer to retire on their own by giving a golden handshake. And who is entitled to the VRS is a matter of rule. Sometimes it's a matter of discretion. And where equality has not been applied, they had challenged the same before the court of law, and the court had to actually look into the matter as well. Can Article 16 be invoked in matters of transfers of public servants? The answer is yes. It has been often used because very often than not, the rules of transfer are not adhered to. Transfers are generally taken as a punitive action against officers, especially to with ulterior motives. Hence, Article 16 has been used because equality means rule of law, and I think that rule of law has to be followed in all sections of the community. Article 16 has also been used for determining seniority, because that I think is the very important element of getting very decorated positions in government. So the decision on seniority list, on promotions and seniorities, all have been taken if suppose there is a grievance, have been redressed through the mechanisms of invoking the provisions of Article 16 of the Constitution of India. Revision of pay, this keeps happening with a lot of pay commissions and sometimes there is no equal treatment on the revision of pay. Those aspects also have been taken due note of under the provisions of the Constitution. With that, I think we'll move on to Article 17, which I think talks about abolition of untouchability. And I think it's very important to understand that this article actually tries to clearly state that the practice of untouchability is forbidden. And of course, there are special legislations under which any such practice of untouchability in any sections of the community shall be punishable offense. So, untouchability, unfortunately, was a kind of a stigma and a practice in this country for a long period of time. However, the Parliament did enact what is known as the Untouchability Offences Act of 1955, and the principal object of Article 17 gets reflected under this act of called the Untouchability Offences Act of 1955. So untouchability created what we call as the social disabilities, because untouchability meant that a section of the community had to be segregated from another section. To a larger extent, there was social boycott. There were two different water well that had to be used, and this was nothing but one form of caste discrimination in the country. So the conditions of living of untouchables during some of the early days were very pathetic. They were denied with a lot of basic civil liberties and civil rights. And I think the constitutional recognition of the ban on the practice of untouchability becomes very, very important message of social equity and equality in the country. Why I say social equity is because I think it is important that resources like water are equitably given to all sections of the community, irrespective of their caste, creed, or culture. That I think becomes the central point and theme of the rule on untouchability. What is important is that please note that the practice of untouchability is an offense not only of the state or state entities, it is an offense that can be also committed by a private citizen or private individual. And hence, this law under Article 17 that says the practice of untouchability is forbidden applies to private individuals as well. So, I think that's what Section 17 is. Everyone, irrespective of his caste, race, creed, or place of birth, has every reason to be treated equally before the law and has every reason to claim equal protection of the law. Now, I think the Constitution, through Article 17, does very clearly send this message that when it comes to morality, when it comes to health or public order, I think everyone has the right as a citizen of India to be treated equally. So your race, your color of the skin, your ethnicity, your origin, your backwardness, you being a tribal, doesn't matter, right? So equality then becomes a very important element of the provisions of law. Moving on to Article 18 of the Constitution of India, which talks about abolition of title, I think you will notice that no citizen of India shall accept any title from any foreign state, except with the previous sanction of the government of India. And no title, not being military or academic distinction, shall be conferred by the state. No person who is a citizen of India while he holds any office, accept without the consent of the president, any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or gift from any foreign state. So, abolition of title is also very, very important. But however, please note, you will notice that the government of India comes up with different kinds of awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. These are called the national awards, and these awards are not amounting to any kind of a title within the meaning of Article 18 of the Constitution of India. This was decided in the case of Balaji Raghavan versus Union of India in the year 1996 by the Supreme Court of India. So you will notice that this kind of Bharat Ratna or Padma Vibhushan, Padma Bhushan, Padma Shri, they are not like suffixes and affixes, right? Or they're not prefixes. So in that sense, you will notice that these are national awards that is granted, but we do generally call Padma Shri so and so, but they're not really titles, and hence the reason why there is abolition of title is probably it has some kind of historical reasons or significance, as the case may be, because I think to a larger extent, you notice that the kings had this title called the Maharaja, or someone says Raj Bahadur or Rai Bahadur, and so on and so forth. So the divans had title, the kings had title, the ministers had title. So I think it was very significant that no longer these titles would be given to these people, and you know that a lot of these provinces, a lot of these territories were brought into mainland India, and it was important to give the declaration that once you have given this territory to India, you no longer are the Maharaja of that kingdom. And that is the reason the abolition of title article becomes very, very significant.